It's my great pleasure to welcome our distinguished guest, Professor Mary Wood from the University of Oregon. We are really honored that Professor Wood accepted our invitation to give an online lecture on a legal approach that she herself originated on the atmospheric trust litigation. Professor Wood is a Philip H. Knight Professor of Law at the University of Oregon and the Faculty Director of the Environmental and Natural Resources Law Center. She is an award-winning professor and the co-author of leading textbooks on public trust law and natural resources law. For example, her book, Nature's Trust, Environmental Law for a New Ecological Age, sets forth a new paradigm of global ecological responsibility. The legal approach called atmospheric trust litigation that Professor Wood originated is now used in emission reduction cases brought on behalf of youth throughout the world. Our Center for Climate Law and Sustainability Studies at the Institute of State and Law of the Czech Academy of Sciences is the first research team in the Czech Republic that specializes in climate change law. And this branch of law is only new and developing here. Therefore, we really appreciate the topic that your presentation brings, Professor Wood, and we will be happy to benefit from your expertise on the topic. And now I'm going to turn over to Professor Wood, please.
Wonderful. Well, thank you again. It's really an honor to present to you all, especially because of the case that was just filed very recently in the Czech Republic on behalf of youth seeking climate action against government. So I'll be talking about those kinds of cases today. I'm first going to share my PowerPoint. So today I'm going to talk about this worldwide litigation campaign called Atmospheric Trust Litigation. And it's against governments worldwide to force climate action. So I wanted to first begin with where I always start my presentations. What does nature require? What are nature's laws? And then we'll talk about the past role of environmental law that brought us to this point. Then I will talk about atmospheric trust litigation because the past law has failed to address climate. And then we'll finish with court's role in the climate emergency and the scientists' role in the climate cases. So that is our progression. I always start, as a law professor, I always start with the supreme law, what I view as the supreme law, and that comes from nature itself. Because we cannot change the laws of nature at all. The best we can do is to try to comply with the laws of nature. I come from a region in the United States where there are many, many Indian nations. And the Indian nations have tribal wisdom that goes back millennia. And this is a quote from just one tribal elder that reflects that wisdom. And it is saying that nature has its own laws. And if you disobey those laws, you pay the penalty. There's no mercy, as Oren Lyons says. So as a law professor, I always begin with that. This is the first law. Now, nature's law has laws for climate, of course. And so the first thing we must keep in mind when we're dealing with climate law is really just to understand what is nature's climate law. And so, as you are aware each and every day, the leading scientists in the world say we have to bring our carbon emissions back down to 350 parts per million in order to stabilize the climate system. So this becomes the paramount law that shapes all atmospheric trust litigation, or it should. We are now, of course, over 410 parts per million. And we are facing something in the law that we literally have never faced before. And that is this urgency. caused by, of course, the feedback loops that you're very well aware of and the tipping points. So if we heat the earth beyond these tipping points, we have violated the law and there's no reprieve. There's no coming back that we know of. There's no way to come back. One of those tipping points, as you all know, is the melting permafrost. And that has become very urgent in the last few months. It looks like we are so close to a collapse of that permafrost. Now, as scientists, you already know this, but I'm putting this first because to me, these rules and these realities have to shape the law because the law can't shape these other realities. They are what they are. And they are recognized by the United Nations. The point of no return is no longer over the horizon. It is in sight and hurtling towards us. That was from the UN chief 2 years ago. And so when we consider these enormous urgencies, our first question in the law really isn't about legal doctrine. To me, legal doctrine is the least difficult. The most difficult part of this campaign is what is the global ambition? What is the goal so that we can comply with nature's law and not go past those tipping points? Now, Dr. James Hansen and leading scientists around the world now say, and I should pause, Dr. James Hansen was the leading chief US climate scientist. He headed NASA's Goddard Institute for Space Studies before he stepped down just a few years ago, I think in 2015. He and other leading scientists around the world and a UN IPCC team say that over the long term, we have to come back. We can overshoot maybe a bit, but we have to have a long-term goal of no more than 1 degree Celsius warming. Now we are going to overshoot, but we have to bring back our climate balance at 350 parts per million and limit the amount of heating. And this is so very important because it defines what the law should do. Now, what do they base this on? There's a study I've cited here. You can go back and find it. Actually, this is a summary, but it cites studies. And you can go back and use that if it's useful to you. But they base it on paleoclimate data and real world observations, just looking at the energy imbalance, the ice sheet collapse, the sea level rise, the ocean warming, and acidification. All of this is happening already with about 1 degree heating. So the point is that we can't heat the planet much more. We will go into overshoot, but over the long run to stabilize, we cannot go over this amount. Now, the problem is, as I will talk more later on, the political goals of the Paris Climate Agreement, which is the worldwide agreement on climate action, sets a 2 degrees Celsius target and an aspirational 1.5 target. Now, those are thought to be capable of locking in dangerous feedbacks. So those are catastrophic. But those define the global ambition right now politically. So we come to this real problem. We've got political targets and we've got nature's reality. And so law is that bridge between the two. That's how I think of atmospheric trust litigation, the bridge between the two. Because 1.5C associated with 425 parts per million and 2C are not safe. So we know we have to get to a fossil-free world very soon, no longer than 2050. We have to fully decarbonize by 2050. But the question is, what does every country do to get there? What are the more immediate targets and the midterm targets? So all that was to talk about nature's law, which is always, again, where I start. Now, I want to briefly talk about how society organizes itself to comply with nature's law. And there we have a partnership, which is why you asked me to speak and why I wanted to speak to you. There's a partnership between law, science, and policy, and it determines each nation's and the globe's response. So this is a little graphic I designed myself. I start with the center, and I think you can see my cursor, right, Hannah? You can see, yeah. And so we start with nature's mandate. That, of course, is paramount. What defines and complies with nature's mandate? Who are the sectors? What are the sectors? Well, science is maybe the most important because it quantifies the necessary reduction. Now, I know scientists will say, we can't tell you what to do, and that's true. But science will say, just as I've elaborated with the Hansen report, scientists will say what the consequences are for each amount of heating. So the science is very necessary to tell us what nature's mandate holds. And then we have the law. The law cannot operate on its own. It can't operate disengaged from the science. The law has to have a very close relationship with the science because the law will force the reduction necessary. But to know what to ask for from government, it has to have science. So there's a very close partnership there. And then policy is the third important piece. Policy would be the government agencies, and they implement the reduction. And then you have this close partnership, and then you have society influencing this whole process, and this process influencing society. So what my goal is always is to match the law with the reality. That's really my dream. And before we talk about how to do that, I wanted to spend a few minutes talking about how the law has failed so far. Because in my own view, the past role of law brought us to this very point. It was law that created, it was, in my view, American law that created this emergency. And you might say, well, how could that be? Because America has more environmental law, I think, than any other world, any other nation on earth. But the fact is, all of these environmental statutes, these are environmental laws, these are the laws I teach. All of these environmental statutes have brought us to this point. Here is a wonderful quote from a science writer. It may seem impossible to believe that a technologically advanced society could choose, in essence, to destroy itself. But that is what we are now in the process of doing. So how did this come to be? Well, in nearly every country, not dictatorships, but nearly every democracy in the world, there's a legislative, executive, and judicial branch. So these are the courts, these are the agencies, these people pass the laws. So this is how it is in America. Well, going back to this, the Congress passed the laws, and the executive, that would be President Biden now, but the agencies implement the laws. Okay. So we had many statutes passed in the 1970s, plenty of statutes. We don't have a lack of statutes, but they gave vast discretion to the agencies. They handed over enormous power to all these new agencies to implement the laws. And Congress thought, and the people thought, that the agencies would represent the people in implementing the laws, that they would carry out the laws objectively. That did not happen because the industries that were going to be regulated began a huge campaign to influence the agencies. And they do this in a number of ways, but the American system, electoral system has been corrupted by campaign contributions. And you all know that, I'm sure. And so a big industry can make a campaign contribution to a president. The president appoints all the heads of agencies. And so obviously there's an expectation of payback. And so this whole campaign financing system has corrupted the government. And that is in large part what has led to this problem. Now, some presidents will toe a straighter line. And I really have hopes that the Biden presidency is doing that. But presidencies like the Bush II and the Trump administration were devastating. And I'll talk about that in a minute. So what you have with industry having so much influence in these agencies is over time they become captured and they start representing industry interests more than the public interests. This is particularly true when the heads of the agencies come from industry itself. And, you know, Donald Trump appointed the CEO of one of the big oil companies to Department of State, Rex Tillerson. And so when these industry heads become appointed to run the agency, you can just imagine, right, how their influences everybody in that agency. So then everybody in the agency has this culture of then using the laws to allow the destruction that the laws were designed to prevent. And they do this through permits. They issue permit after permit after permit to destroy the very resources that the laws were designed to protect. I've written about this in my book, Nature's Trust, and I won't go into any more detail now. But an example is the Clean Air Act. The Clean Air Act was passed in the early 70s and has always had the authority to regulate greenhouse gas emissions, but it's never been used that way comprehensively. In fact, most of the greenhouse gas emissions are permitted pursuant to permits under these laws. Congress has been very influenced by money, and so it has been passive. It is not engaged in the climate problem for the most part. So for decades, the government has known, our government has known for decades that this problem would get worse and worse until our generation would face an all-out emergency. And here's just one document. There are thousands in the Giuliani case that are logged as part of the record. But here's just one document that shows what I'm talking about. This was a letter to President Nixon from a close aide warning of sea level rise back in 1969. And he said it would be so bad it would inundate cities on the East Coast. And this is a quote, "Goodbye, New York. Goodbye, Washington, for that matter." So the point I'm making is the government knew all along that this was a crisis that would get worse and worse and would land on our shoulders. The courts were ineffective. They created their own role in this that was very passive. The claims that came to them were under the statutes, and they were very, very narrow, and many of them procedural. And the courts gave deference to the agencies, thinking naively that the agencies were trying to represent the public, whereas in fact they had become captured. And so because the courts were ineffective and because Congress was sort of missing in action, we've only got 3 branches of government. And so the third branch took enormous power that was aggregated. And so the executive branch gained this unprecedented control over the nation's ecological wealth. Now, I'm speaking in terms of America, but this really happened in many countries throughout the world because the American environmental law system was exported, if you will, and other countries adopted these same systems and have the same dynamics with their agencies. So when we get to the international level, we have countries coming together to talk about climate ambition. But the problem with that is if there is not domestic will in the executive branch, then the negotiators from that branch that come to this room, they have no more ambition than their domestic nations. And so what happens is it becomes extrapolated. This problem becomes extrapolated and magnified and transferred to the international level. And whereas everybody says, well, international law should take care of this, there is no international law. There's international commitment, but there's no international law. President Trump pulled America out of the Paris Climate Agreement, and no country could do anything about it. And so there's not really over enforcement authority. So the political dysfunction resulted in a political goal of 2 degrees Celsius, which has been deemed catastrophic by leading climate scientists worldwide. But that is the stated goal. So we'll get to the law in a minute because that goal influences the court cases. But the point is, the decades were squandered. We could have had orderly transition and we did not because of industry's grip on government. Now, before I get to the legal cases, and that is my next step. So I want to take a pause and think about where we are and how we got there in another way. And I always bring up this quote to take this pause and to envision the court's role. This person is John Holdren. He was the science advisor to President Obama. He was from Harvard University, scientist. And he said back in the Obama administration, with respect to climate, he said, the current situation of the world is we're in a car with bad brakes driving towards a cliff in the fog. And that was a good description. President Obama was approving oil pipelines. He actually did not really prioritize climate until his last year or so in office. And then we had President Trump come in. And President Trump came in with a campaign pledge to develop $50 trillion of fossil fuels from America, coal, oil, and natural gas. And for his entire presidency, he pushed and pushed fossil fuel development. So America became the leading exporter of oil and natural gas in the world. Just when we should have been slamming on the brakes, we had a president in the front seat of this car who was pushing his foot down on the accelerator towards that cliff to get us to that climate cliff as fast as we could. And what I tell people is, we're all in the back seat of that car. Even though you're all from a different country, you too are in the back seat of that car. You are, I am, Michael is, we're all in the back seat of that car because American fossil fuel development and every other country's fossil fuel use is going to determine whether we go over that cliff. And so we are all in the back seat. And during the Trump administration, my question to people was, don't you want a police officer to pull over the car before it goes over the cliff? And most people say yes, because they're in the back seat with our children and our future grandchildren and descendants. So the police officer is the courts. Only the courts have the authority to pull that car over before it goes over the cliff. That is how I think of the courts. Now, there has been a judicial awakening worldwide, and I'll talk about this, but the Giuliani case, which I will talk about, is the foremost American case, had an opinion from the Ninth Circuit that I'll go into, but basically the judges said, we are on the eve of destruction. These are American appellate judges saying we're on the eve of destruction and recognizing the point of no return. So this is amazing that the courts now have had an awakening. That's very, very good. And courts around the world are waking up to this. They're understanding this emergency. But we also have to understand that we're at a point in law where the President of the United States and the leaders of other countries have now unprecedented power. And the law has never dealt with that before, because nature has, it is as if nature has given them this power, because they are the closest to the climate cliff, if that makes sense. The presidents before still had time to avert the cliff. But a judge on this appellate case said the government, that would be the American government, insists it has the absolute and unreviewable power to destroy the nation. So I just want to, before getting into the law too much, I want us all to recognize the law has never dealt with this kind of power. It's dealt with power over social affairs and economic affairs. It's never dealt with governments wielding this much power because of the situation of nature. So we're in a climate emergency, and courts must recognize that this is new. It can't be treated under the old boxes of law. It is something entirely new. So now I want to turn to atmospheric trust litigation. And this was an approach I originated because of the failure of environmental law. And I conceived of it in 2007 and wrote chapters on it, and ultimately a book including it. And I don't litigate. I'm a law professor. I'm not a lawyer who litigates. So other lawyers, litigators, would have to take this up, and they did so. And now this campaign is worldwide, as you'll see. And when I talk about the worldwide atmospheric trust litigation campaign, I really include all the cases that have been brought where citizens, and usually youth, are challenging their government. And they may not call this atmospheric trust litigation, but it's all part of the same pattern. So I put it all together as atmospheric trust litigation. And when I came up with this here, I'll show you the little picture there. When I came up with this, I had several premises. I knew that statutory law would never work in time to avert tipping points. In fact, a very high-ranking attorney of the US Environmental Protection Agency told me in 2007, the Clean Air Act will never work in time. This agency will never act in time because it's politically compromised. And then, of course, international law would fail because the domestic dysfunction gets transferred to that level. And I thought that judicial intervention would be necessary within each country, not just America, but each country. And what I tried to do was design a common basis of law and science, because we share one planet. So the science should be common, but also have a common basis of law so that judges in courts in other countries can have a legal basis to enforce climate responsibility. So I envisioned that these cases would come about probably at the 11th hour, and they have. The legal system works kind of slowly. So what I did was elaborate a doctrine that is the oldest doctrine of law in, I would say, non-Indigenous systems. And it's reflected in Indigenous systems as well in a different way. It's called the public trust. And one of my colleagues calls it the law's DNA, because it's found in some fashion everywhere in the world other than dictatorships. It goes back to Roman origins, and the Roman law is the basis for every country's law that is non-Indigenous across the world. And the Institutes of Justinian back then said, by the law of nature, there are certain things common to humankind that you can't put into private property. In other words, humans have rights to certain common natural resources. And one of those is the air. And then, of course, the water and the oceans. And so court cases have come down over decades and centuries in US law, elaborating this public trust. It is a firm part of American law. And my colleague Charles Wilkinson says this doctrine came up because some resources are just so important that they have to be protected by courts. So this body of law is outside statutory law, and it has constitutional force. It actually can be used against legislators. And the basic essence of the doctrine is that whether it's in America or Uganda or Germany, any sort of country that has the roots of the trust, say that the public has a property right in certain natural resources that are essential to survival. So you can think of it as an ecological endowment, a trust. We use the term trust in our country. Many other countries, especially in Europe, they don't use the term trust, but it's the same thing. It's an ecological endowment for present and future generations. The idea is that we shouldn't destroy everything in our generation, because then our children won't have anything to survive and their children won't either. Very simple concept. So in this country, we say government is a trustee of natural assets, and the assets are the wealth of the trust, the rest. In other countries, they may not use the word trustee, but essentially that's what they mean, a steward. The second concept is present and future generations actually own these assets. So the government doesn't own it. The government works for us, not the reverse. The government works for us, we, the people. And they are the managers, but we actually, the people, own these resources for posterity, all together in trust. And so from that, government has a fiduciary obligation to protect these natural resources. And if they don't, they won't be around for future generations. So there is a legal obligation in US law to protect these for future generations. And when we see cases coming out from other countries, climate cases, they all talk about government obligation. So they really are premised on this idea, even though they don't talk explicitly about the trust. But if you look at this, this will be meaningless unless the fiduciary obligation is tied to nature's reality. I hope everyone can understand that at this point. If it's not tied to nature's reality, it really does no good. So this trust, public trust concept, was long in place before any constitutions were written. And so in America, it is often thought of as a slate upon which the constitutions were written. So you may have many, many constitutional rights, but the oldest grounding was the public trust. And all these other rights emerge really from that. And in this country, we view the trust as inalienable rights that the people have against their government. And I want to make that clear. It's not something government gives us. We reserve the rights in a democracy to hold our government responsible for protecting these assets. Now, the only way to really have meaning in this trust is to enforce it in the courts, because the governments don't enforce it on their own. And I want to point out that US courts have enforced fundamental rights for decades in this country. And I won't go into all of these, but there's prison cases and civil rights desegregation cases and treaty rights cases and so forth. And these are cases that are very complex, and the courts get in there and enforce the fundamental rights. So when I designed the atmospheric trust litigation construct, I had these remedies in mind, thinking the public trust is a fundamental right, and courts can borrow these tools that they have used before and use them in enforcing public trust rights to the climate system. these are cases that involve very long-standing, kind of baked-in violations of fundamental rights. And so they're not just simple win-loss cases like a divorce case or a contract case. The judge says, you win, you lose, goodbye. No, these are ones where the judges become engaged with the remedy, and they stay engaged for decades. This treaty case has been going on over 50 years in the Pacific Northwest, very successful litigation. So the court's role in this is very distinctive. The court imposes sidewalls, defining what it will take to comply with the fundamental rights. And so this is a really important role, because if we're talking about climate case, the court has to define what is that level of ambition necessary to protect the climate rights of future generations. So this is a really important part. And who helps the court define it? Scientists. So I'll get to the role of scientists in a minute, but this is where the science comes in. And then the defendants, that is the agencies, the policymakers, choose what measures to bring forth to implement those standards. So the court doesn't say you have to, have this many solar roofs across the city, or you have to close these numbers of airports, or you have to close this coal-fired plant. The court doesn't say any of that at first. The government defendants bring a plan, and they design the compliance, not the court. And many people, the defendants love to say, oh, the courts will tell us to do this, this, and this. No, that's not how it works. It's the government's responsibility as trustee to bring a plan to the court and design that plan. So then the court approves it or not. The court reviews it, see if it is complying with the standards, see if it goes far enough. And then once a plan is approved, a court will supervise its implementation and impose deadlines. It's almost like, a parent's role in homework for a kid. The kid maybe doesn't do the homework. So the parent says, well, I think you should do the homework. And what is it? And the kid says, well, I have to write a 10-page essay by Wednesday. And so the parent says, well, okay, bring me back a draft. Let me see you get started. But the parent doesn't write the draft. So the kid comes back maybe Tuesday and has only 5 pages. And the parent's saying, nope, nope, nope. The standard said 10 pages. Go back and bring me 10 pages by midnight. So that is how this works. The court supervises the process and imposes deadlines and reviews it. But there's a lot of judicial work in this. The courts have clerks, and they vet the remedies. They review the science. It is actually, there's a lot of value added to the climate remedy when a court gets involved, because you suddenly have a forum that is not political, where scientists produce evidence, and the courts can review that evidence and decide if the plan actually will carry out the appropriate levels of reduction. So there's a lot of value added if the system works well. I'm not saying all courts work well, but if they did, there would be value added. So in May 2011, again, I told you I don't litigate, but in May 2011, attorneys filed these cases through our Children's Trust, which is an organization I'm not affiliated with, but they're in Eugene, Oregon. And they are the leading organization taking this global campaign forward, but they partner with lawyers around the world. And in 2011, this campaign started in America with a hatch of cases. And these were cases and petitions filed in every state in this country and against the federal government. And there was a case in Ukraine. So many of these were just administrative petitions. but many were cases as well. And that led to a global atmospheric trust litigation campaign. As climate attorneys saw what was going on in the United States, they started filing cases as well. So the early cases in America were premised on the public trust only. And the complaint said the error is held in trust for us youth. They were all filed on behalf of youth plaintiffs. And the youth said, government, you are the trustee, and you have a duty to prevent substantial impairment. That's the legal standard in our country. A legal duty to prevent substantial impairment, and that is defined by science, not politics. So the design of this litigation is that it connects law with science, that it allows an avenue for scientists to provide evidence of what the climate system needs to recover. That is a lot different from, congressional hearings on climate, where it's very political. There's no vetting of the evidence. There's no methodical system for making sure the truth is told. And then the cases sought enforceable science-based plans. And again, that goes back to the model of institutional litigation that I told you about that had come from these other areas of law in America. So what we needed was a prescription for the planet. At the time the cases were, or right before the cases were filed, that was when the scientific community went from deciding 450 was protective to deciding it must be 350. And you all may remember that, but Dr. James Hansen really led that recalibration. He was the chief climate scientist for the United States of America. He went to to a major climate conference and said, 350 has to be the goal, 450 will lead us into disaster. There was no prescription, there was no scientific advice showing how much emissions reduction was needed to get to 350. And it's not just emissions reduction, it's also absorbing excess carbon dioxide already in the atmosphere over 350, sequestering it and drawing it down. So it's not just decarbonization, it's also cleaning up the sky, almost like you would have to clean up an oil spill, because we have to get that excess carbon dioxide over 350. We have to get that cleaned up. But for this presentation, I'm just focusing on emissions reduction. And so I called Jim Hansen, and he was at his farm, as I recall, and it was on Memorial Day. And I said, is there a scientific prescription showing how much emissions reduction would have to occur each year to get us back to 350 with the sequestration as well? He said, there's no such prescription right now. And I said, would you develop one? And he said, well, yes, I will. So he assembled a team, a worldwide team of scientists, and they developed what I call the climate prescription. And it was published in PLOS One, and this is a little picture of the front of the article. And basically, back at that time, you can see the carbon emissions going up on the red line, and his prescription would have taken it down. The blue line, this is just a graphic, it's not really precise. But he said, his team said, if you started in 2015, you would need a 7% emissions reduction every year. And then also the sequestration to get the climate stabilized at 350 by the end of the century. Well, all of that science and law that was happening in the United States started being noticed around the world, and lawyers around, and this is a big jump, I realize, but lawyers around the world began bringing these kinds of cases. And I call them atmospheric trust litigation cases because they're patterned after the United States case for the most part, although they have different laws that they involve. But right now there's cases in all these countries, and they involve suits brought by citizens, often youth, against their governments seeking emissions reduction urgently. And of course, the Czech Republic just had a case filed. I'm going to get this so you see this. April 2021. So it is the most recent case. And that's very exciting. So all of these cases have a similar construct, including the Czech case. Let me just move this box down here now. They generally sue several agencies of government, and that's a good thing because it's not just one agency, it's several involved. So it may be transportation, energy, environment, all of those. And they assert fundamental rights. So these are not statutory rights usually, they're fundamental rights. And usually they have the rights of future generations mentioned. So many of these don't actually assert explicitly the public trust. But again, I think the public trust concept underlies all of it. The government has a trustee obligation to protect vital natural resources. But here's from the Czech case, and I gained this from a little summary that Teresa was nice enough to send to me. So the Czech case has these rights mentioned in its complaint, very similar to other cases, although other cases might be enforcing the Paris Climate Agreement or the European Convention on Human Rights or any number of laws. So when I talk about these to people from other countries, I explain it like this. Every country has different laws, and what lawyers do is they try to find a little hook. Whatever hook is in that country's law, they'll use as long as it's fundamental rights. Fundamental rights can be enforced by courts in a different way than statutory rights. When you enforce a statute, you give deference to the agency. You're in that one line of law that failed. When you enforce fundamental rights, the courts have a lot more latitude and power to enforce the rights. But the key in all these cases is matching the law to nature's reality. So it's very important that the court actually define the appropriate targets in order to actually fulfill the duty. Unfortunately, many of these cases tie to the Paris 2-degree goal. And that is kind of ironic because that means that they're asking a court to enforce a catastrophic pathway. So there is a problem there. But if the standard is correct, then the courts can play a hugely productive role in setting timeframes. This recent case from, I think it was France, established 3 months for the government to come back and deliver different emissions targets. So courts can be that parent who makes the kid do the homework on time. And there's really no other institution that will force government action so quickly as a court. They play a huge role. Well, I'm going to quickly tell you about the Giuliani case, and then we'll finish up. The Giuliani case was the biggest case in the United States, is the biggest case in the United States. It was filed in 2015. Again, it inspired many of these other cases in other countries. It was filed on behalf of 21 youth against almost a dozen US agencies, every agency involved in the climate system. And it was filed here in Eugene, Oregon, in the Federal District Court of Oregon. Now, the 21 plaintiffs are youth, and they challenged the entire fossil fuel policy of the United States. So this is very different from statutory law. Statutory law, you can only challenge one little action here, a little action here, another action here. This was the macro approach, challenging the whole policy. And it has been called the biggest case on the planet because of that, because the United States has such a huge fossil fuel system. The complaint, I keep having to move this little box so you can see the, I'll move it up again. The complaint amassed those documents showing the government knew all along it was causing us to be in this existential crisis, and said the government has acted with deliberate indifference to the peril they knowingly created. This was the very first fundamental rights lawsuit in the United States in the environmental area. All other lawsuits had been on statutory grounds. And these were the claims under the US Constitution and a public trust claim separately. The remedy was the youth sought declaratory relief, which is a declaration by the court that the climate system had to get back to 350 parts per million. So immediately it was tied to that science, which shows that 350 is necessary. It was not tied to the Paris Climate Agreement at all. And it had as one of its major scientific documents, this +1 prescription that I told you about. This is it right here. Also, James Hansen was brought into the case as the leading climate expert. He had to step down from his position in government to become an expert against government. So he did that for this case. And then they sought a judicial decree. That means they asked the court to force the government to come forth with a plan to bring our energy system into compliance with 350 based on emissions reductions that scientists define. And the court gave the plaintiffs a major victory, did not allow the government's motion to dismiss. And Judge Ann Aiken made history by saying, this is a civil rights action. This is an environmental case, but it's a civil rights action. And she found that, yes, the youth had constitutional rights grounded in both the due process clause and the public trust. And in words that really made it around the world within hours, she declared a US American constitutional right to a stable climate system. She said the right to a climate system capable of sustaining human life is fundamental to a free and ordered society. So that becomes the constitutional right that the standards have to come into compliance with. A trial was set for 2018, and all of this evidence was put into the record, including the science that it would take to create a stable climate system. There was also evidence on decarbonization pathways. And these are all found, and you can go back to this. All of these filings are at the Sabin Center's wonderful climate chart. So there's the link. But the Trump administration was elected, President Trump was elected, and his attorneys made unprecedented efforts to derail the trial and force an early appeal. And they gained that. It went up on appeal to the Ninth Circuit without having had a trial. That is very irregular, and it was very unfortunate because the case had not had that judicial vetting. The trial court had no opportunity to even begin on a remedy and figuring out what would work and what wouldn't work. It went right up to appeal, so it was a hypothetical sort of case. And that was a shame. The youth lost on the Ninth Circuit, the Ninth Circuit level. They focused on the remedy. And I think these words will shock you. There were 3 judges. These are the 2 that decided against the youth. There was 1 judge that would have decided in favor of the youth. But they began their opinion saying, yeah, we're on the eve of destruction. They understood the science. They completely understood government's failure to change and said that may cause environmental apocalypse. And they found that the claims might be viable, but they said reluctantly, such relief is beyond our constitutional power. So they had the science right. They agreed there could be viable claims. I don't want to get ahead of myself, but they said the courts can't be involved at all. Well, remember, we have only 3 branches of government. And the reason we've come to this climate cliff, is because one branch got too much power. And it takes the courts, the police officer, to pull over the car before it's too late. And these are 2 judges that said, no, courts can't be involved at all. This was the 3rd judge, and she dissented. And she said, it's as if an asteroid is barreling towards Earth and the government has decided to shut down. And it claims the power to destroy the nation. And the other 2 judges did not disagree with that. So this judge said, government has no right to engage in the nation's willful destruction. She would have found a role for the court. And this is a quote she ended with, which I think is influencing judges now around the world. I think they're reading her dissent. History will not judge us kindly when the seas envelop our coastal cities and fires and droughts haunt our interiors and storms ravage everything between. Those remaining will ask, why did so many do so little? And this is an example of one judge with the power of her pen, I think, again, influencing courts around the world. I think judges in France and Germany and Ireland, I think all of them are reading this quote from her and thinking about it. So I'm going to start wrapping up. I was given an hour and I'm coming up. I have a few minutes left, but not many. So I'm going to start wrapping all this up and putting it together for you, and then we can discuss. So Giuliani inspired so many cases, but ultimately so far, it lost at the Ninth Circuit, but it has the sound science on the targets. And by that, I mean, and it's hard to really convey this, but it took a body of science and put it into the judicial record. It's available to all of you. It is available to judges in Germany and Australia and Pakistan. Everybody can have this science because it is in the docket of this case. And that docket has been compiled by the Sabin Center at Columbia University. So I have a link to that science as we finish up when I talk about the role of scientists. But the point is that this case is primed for a historic decision because it has the leading science that is actually tied to nature's mandate. Now, people thought after that Ninth Circuit decision that the only next step would be to go to the US Supreme Court. But that's not what is true. The plaintiffs actually filed an amended complaint before Judge Aiken. So the case has not yet left the district court. It's back in the district court, and Judge Aiken will be in the position of deciding whether or not to allow the amended complaint. Now, if she does, I believe it is fairly sound for me to say that it could stay in the district court, have a trial, and maybe the Biden administration would either come to the table or be forced to come to the table to engage in settlement discussions with the plaintiffs. So we'll see what happens. There's a lot of unknowns right now, but it's not in the Supreme Court of the United States. It's back in the district court. Meanwhile, the ATL cases around the world have had stunning victories. And again, they've asserted claims based on whatever fundamental rights are in their country's law. And they are winning, but many of them are tied to targets that are catastrophic, the 2-degree Paris target. And those can be probably changed in the courts, but they need to be understood. So I'm not going to talk about every single case. I'm just going to show a series of slides which show you the winning cases, just huge victories in Pakistan, Colombia, the Netherlands. And in the Netherlands, the court actually ordered the government to reduce emissions 25% by the end of 2020. That was within a year. I think the government had agreed already to reduce, or had determined it would reduce 20%, but the court raised it by 5%. All of these courts have rejected the argument that this is a political question that the court should not be involved in. They all go against those 2 American judges that said climate is a political question, the courts can't be involved. All of these courts go against that, to the extent that commentators have actually said that those 2 American judges, that opinion is a renegade opinion. We'll see, but other courts definitely think the judges should be involved at this last moment. Ireland had a huge victory. France, just very recently, the French case gave 3 months to the government to come to court and demonstrate that its emissions reduction was on track to meet the Paris goals. So 3 months, very, very strict time frame, but again, tied to the Paris goals. The German victory just a few weeks ago said that the German Climate Act was unconstitutional because it put most of the burden of emissions reduction on future generations. It said, you come back and bring us new targets by the end of the year. And so if you want to summarize all this, you could say the Giuliani case has very sound science and a huge body of science in the record that anybody can use, but it has no judicial resolve. The Ninth Circuit, 2 judges said, we won't have any role for the courts. And I should add too that there was a process for the whole Ninth Circuit to reverse that, and they declined to get involved. So it's not just those 2 judges, but they definitely are at the center. But the other cases show, around the world now, show judicial resolve, but the targets are often tied to a catastrophic course. So how would the Czech Republic case influence these cases? You can see that there's now a green judicial domino effect, which is very good. The court, in my opinion, the courts are getting involved at this 11th hour. And now every judge who has an ATL case in the world will be looking at other cases. You read these cases, and the Giuliani case cites the Netherlands case. The French case will cite the German case, I'm sure. So all of these judges know about their other cases, and it's becoming a body of law. So the Czech case is important because it's one of these cases. And even though it's limited to the Czech Republic, it still can influence other cases. And so what would the court's role be in the climate emergency? Again, the court should define the necessary emissions reduction to achieve the compliance with fundamental rights, require a plan to achieve it, make the government do something rather than just sit by, and supervise the plan. Now, if necessary, a court can also issue backstop injunctions. What that means is they can stop the damage on an issue-by-issue basis. So in America, they could put an injunction against, that means stop, oil drilling on public lands, for example. Judges can do that. They can say no oil drilling on public lands until you come back with a plan to restore the climate system. So the courts have that authority. And my last couple minutes is the scientist's role. Scientists play a huge role in atmospheric trust litigation. They are the experts that provide declarations to a court, expert declarations saying what nature's mandate is. And I've talked a lot about the Giuliani case and the role of science. You can all go to the Sabin Center climate chart. On June 28th, 2018, there was an entry of about a dozen scientific declarations in this case. So they are in the judicial record, and those, it seems to me, can be used in any other case in the world and are very useful. The Jim Hansen Declaration is in there, talking about the need to return the world or cap the long-term heating at 1 degree. Scientists are also doing amicus briefs. Groups of scientists are providing a brief or briefs to the court to give their perspective on science. So not only do they have expert declarations, but they also provide legal briefs. And those have been done in the Giuliani case, in the state cases in the United States. And those are all very easy to find as well. You can go to Our Children's Trust and they have the docket of the Giuliani case. It's also on the Sabin Center climate chart. And of course, Michael and I can always help with tracking these things down. And then scientists also just are so useful communicating science in climate cases to the press. That's the link with society that is so important, because ultimately society has to be a part of all of this and not just have the feeling that the courts are determining their future. So I'm going to end with this quote. I think I'm right on time. It's a quote from one of those scientists' amicus briefs that Dr. James Hansen led, and it was put into one of the, I think it was either the first federal case or one of the state cases. But these are the scientists speaking to the court saying, judicial relief may be the best, the last, and at this late stage, the only real chance to preserve a habitable planet for young people and future generations. So thank you.